There are major new developments tonight in the trial of George Zimmerman, the man accused of murdering 17-year-old Trayvon Martin. Zimmerman has pleaded not guilty and claims he shot Trayvon in self-defense. With less than 3 weeks to go until the trial, the prosecution is now asking for a gag order against Mr. Zimmerman's lawyer, Mark O'Mara, saying he's trying the case in the press instead of the courtroom. A judge will consider those arguments in what's shaping up to be a major hearing next Tuesday. The gag order motion comes after an important week in the case. The Zimmerman team released numerous photos and documents that appear to be designed to paint Trayvon Martin in a negative light. Also developing, the defense team is asking for a delay in the trial in order to challenge a key piece of the prosecution evidence. The Orlando Sentinel reports the defense is focused on a 911 call the night of the murder. That's what the call, that call is what that led to the defense asking for a delay in the trial. These are critical questions, and the answer could determine whether George Zimmerman is convicted or set free for the killing of Trayvon Martin. Joining me now are Kendall Coffey, former U.S. attorney and now criminal defense lawyer, and veteran prosecutor Paul Henderson. Kendall, let me start with you. This is actually the third gag order the prosecution has filed. Why are they so concerned about Zimmerman's lawyer going on TV talking about this case?
Well, they're concerned because it's 3 weeks to go and a lot of stuff that is inflammatory, that would never get to first base in a court of law, stuff the jury would never see, is scoring some home runs maybe in the court of public opinion. It's inflammatory, it's damaging, and frankly, potential jurors are going to find it very hard to unsee what they're already seeing in the television, the internet, and in newspapers.
Now, Paul, do you agree with that? Because clearly O'Mara, Zimmerman's lawyer, is out and saying why he's releasing this. Let me give you why he says these texts that he's put out about fighting is relevant. Listen to this.
You know, if we're talking about who Trayvon Martin was that night, if that becomes relevant according to how the state presents it, then the idea that this is a person who's familiar with fighting, familiar with getting on top of somebody, another text that was there, I think that's very relevant for a jury to look back and say, what did happen in that 1 minute or so that we don't have audio evidence for?
Now, is that something to be concerned about, Paul? Is that damaging? Could that pollute a jury pool?
It could pollute a jury pool, and that's exactly why they're asking for the gag order again. And in this case, with that evidence, those photographs and those texts, because we know that a judge would not admit any of those things, that's the basis to ask for a gag order again. The only reason that they are including it in these in limine motions, and the only reason that they're including it as evidence that they would like to introduce, when they know that it won't be introduced, is to try and taint the jury pool and to try and change public perception with this information that they have that, quite frankly, is very disappointing to see that they're trying to release and introduce into the trial. It just is not going to happen with the limited means in which you can even use character evidence in a self-defense case in Florida. It's a real disappointment. It's absolutely prejudicial. I would hope that a judge does restrict it and enforce a gag order against the defense in a case like this.
Now, they're asking for a delay, Kendall, because of this. There was screaming in the background of a 911 recording. The prosecution's voice experts say those screams are Trayvon Martin's screaming. Listen to this.
911, do you need police, fire, medical?
Maybe both. I'm not sure. There's just someone screaming outside. I think they're yelling help, but I don't know. Just send someone quick. Say stop.
Okay. Does he look hurt?
I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him.
So you think he's yelling help?
Yes.
All right. What is your phone number?
There's gunshots.
Now, Kendall, the prosecution say that they can put experts on that says that's Trayvon Martin. It's clearly that is screaming in the background as this person is making this 911 call. The defense, of course, is saying they need time. It's not clear whether they're going to try to counter that and say it's not Trayvon or come with some expert that would try and discredit it. Why is this so important if, in fact, that is Trayvon Martin screaming, as some of the experts have said?
Well, of course it's critical, because if, in fact, the prosecution has a reliable expert who's going to say that's Trayvon Martin's voice, that's a very big issue, and that strongly supports the prosecution theory. But for the defense to act surprised when this has been a very central issue for 16 months, the 911 tape, the question of whose voice is on that isn't going to go anywhere with this judge. So whatever their rationale is for seeking delay, I'd be astonished if this judge buys this particular excuse.
But Paul, why do you think, I see you nodding, why is this important in the trial? If this, in fact, is Trayvon, and the jury believes this to be Trayvon, what does this do in terms of the evidence in the trial?
Well, this tape and that audio recording is going to be almost the linchpin to define how both sides see whatever happened that evening, right? So the prosecution is going to say that you can hear him screaming, Trayvon, trying to get help and yelling out. The defense does not want that key evidence to come in, because that kind of colors the whole basis that the prosecution is making their claims on. And so they will do anything they can to diminish, to modify, or to delay that evidence coming in. And even if all they're able to do is throw out the prosecution's witness and have them choose a new expert, it's one more delay, one more modification, one more thing that may diminish the prosecution's case. It's really unlikely at this time, at this late notice, that they're challenging it. And that's what, to me, again, it's not only disappointing, but it's an expected defense tactic that I'm hoping does not work, that the judge will be able to see beyond that and allow the prosecution to put on their case with all of their evidence.
But Kendall, the judge, we've seen that the prosecution has said they have an expert that will testify this is Trayvon. If, in fact, this person can establish that it's Trayvon, we just saw tape where the attorney for Mr. Zimmerman said that Trayvon had a record of fighting and knowing how to get on top. It'd be difficult to claim he was on top and all if, in fact, he's the one yelling for help in these in the background of the person making this 911 call.
That's why it's so critical. Remember, Zimmerman supporters have been saying it was Zimmerman crying out for help, that Zimmerman was the victim. If indeed the prosecution can establish that that voice, the voice crying out for help, was the voice of Trayvon Martin, then it's going to be very, very compelling as to who was the aggressor, who was the real victim, and who should be perhaps judged guilty for second-degree murder.
Now, let me ask you another question, Paul. Zimmerman's lawyer is pushing some very extreme sequestration of the jury pool. And let me read to you what I'm referring to. Amara has said in an interview that he's going to ask a judge to sequester not only the jury, but the jury pool in the upcoming trial. That may involve sequestering 500 potential jurors in order to find 6 people who can serve on the jury. Now, it sounds wild to me, but is that unusual to sequester hundreds of potential jurors?
It is unusual. You do sequester a larger number in a case like this, where you're going to go through possibly 100 people to get the people that you need on your jury pool. And keep in mind, this is what the court is considering. After they get their actual jurors, this could be a long trial, and so you want to have enough people that you held to the side that can make up replacements in case someone in that jury pool falls sick or someone in the jury pool falls out. You don't want to declare a mistrial or have to redo the trial. Right. So it makes sense to have a sequester done where you have a large number. But when you're asking for hundreds like that, not only is that not likely to happen, but to me, that's a delaying tactic at this point. The judges know what to do. The judge knows how many people that they want to put aside, and he doesn't need input from the defense attorney to take this off track, and delay this trial any longer than has already taken place already. And so that's how I look at his motion in the first place.
So, Kendall, do you agree that it's unlikely the judge would set hundreds aside in sequestration? And I'm reading, this was in the Washington Post, to get 6 jurors. Why only 6 jurors here?
Yeah. Well, it's not a capital crime.
Right.
In other words, 6 jurors is a normal number of jurors in Florida. And I certainly agree that he's not likely to get hundreds sequestered. And think of how ironic it is. Omer saying he is concerned about sequestering hundreds of people in order to avoid the effects of pretrial publicity. Meanwhile, he's working the press, trying his case in the court of public opinion, throwing out stuff that's obviously inflammatory and inadmissible. That makes it pretty tough to come to the judge and ask for some extraordinary protection against pretrial publicity.
And non-capital cases in Florida is only 6, not 12 members of the jury.
Correct.
We're going to stay and watch this one all the way through. Gavel to gavel, we'll be covering this trial. Kendall Coffey and Paul Anderson, thank you both for your time tonight. And full disclosure, in civil court, George Zimmerman has sued NBC Universal for defamation, and the company has strongly denied his allegations. Still ahead.